Well, hello and welcome to another of my daily updates around the California Board of Psychology hearings that are coming up December 29th through the 31st. Today, I'm going to be talking about my respondents' formal defense and the exhibits. I just posted them to my consulting website, so you can go and get and see all the documents there. So here's what it looks like on my website. It's Dr. C.A. Childress or at consulting.com. And forgot an S on my name. The Board of Psychology there, and you see my defense documents at the top, and then there's the four motions in limine and the oppositions. And then I have all the exhibits. I have 30 exhibits. And the part of the reason for that is you'll find on Exhibit 30, which was my settlement counter offer to the board, where I wanted to discharge my duty to protect to the Board of Psychology because normal routes into the Board of Psychology are closed due to various institutional features, institutional capture features. And that's why no parents have been able to get protection over the last 40 years, is because the boards won't accept reports coming in through normal channels. And now this situation here provides me with an opportunity to directly speak to the board and have their full attention for 3 days. And so I attempted to discharge my duty to protect to the California Board of Psychology. They declined to accept the discharge of my duty to protect. And if they decide not to accept the duty to protect, then I still carry it because I have to discharge it to somebody capable of protecting these parents and children. So I'll be discharging it now to the hearing and the documentation surrounding the hearing, and then to subsequently until the parents and children get proper protection from abuse, child abuse and spousal abuse. Let me say something about the spousal abuse for a second too, because this is one of the most, not one of the most, this is the most brutal form of spousal abuse possible I've ever encountered. Now, I come out of child abuse and I've seen a lot of bad situations, a lot. The spousal, emotional, and psychological abuse of the targeted parents is phenomenally off the charts. They're basically having their children killed. Yeah, that the pathological parent is basically killing their children psychologically, emotionally. They lose their children for the rest of their lives. That is the most brutal form of spousal abuse. In addition, they are forced to watch as their beloved children get distorted and mangled into these angry or fearful and just not the lovely, healthy children that they are. And they have to watch that over years as they fight in the family courts and they fight with the mental health people, and the mental health people just don't protect them. They don't do anything. The courts don't do anything. The courts don't do anything because the mental health people aren't getting the courts the proper information, high quality information about what's going on. There's only two possible causes for a child rejecting a parent, and either one is child abuse. It's either child abuse by the targeted parent, and the child's fleeing from that parent. But if it's not, then it's psychological child abuse by the allied pathological parent, narcissistic, borderline, dark parent, creating a persecutory delusion, factitious attachment pathology in the child for secondary gain to them, DSM 5. Would people, mental health people in the family courts, please, please, please start using the DSM 5? That's what it's there for. It's a delusional disorder. It's a factitious disorder imposed on another. Two major psychiatric disorders wind up on child abuse, not parental alienation, child abuse. Let's please start using the DSM 5, but these parents cannot get a diagnostic assessment. have not been able to get a diagnostic assessment for 40 years because of the institutional capture by the forensic custody evaluators. And so they don't diagnose and they treat. They're doing an experiment on human subjects. And so it is phenomenally bad in situation in the family courts. And I'm trying to protect them, but I have nobody to protect them. There's nobody that's doing anything about it. So for 15 years, I have carried a duty to protect the children and parents in the family courts from child abuse and spousal abuse, and no available location to discharge my duty to protect. I have directly asked the California Board of Psychology to receive my duty to protect the children and parents. That's my settlement counteroffer. But the Board of Psychology has refused to accept the discharge of my duty. I therefore continue to carry a duty to protect the children and parents from abuse and will be discharging this duty to protect through the documentation of the 2029-2031 formal hearing and subsequently. So the situation in the family courts is there is an identified victim, that's the children and parents, and they are in imminent danger of abuse with lifelong consequences. So they represent the children and parents in the family courts represent a vulnerable population who warrants special protections under the principles of the Belmont Report. They are not receiving those protections. They are being experimented on without oversight in violation of 8.01 of the AP Ethics Code, in violation of all three principles of the Belmont Report. The children and parents in the family courts represent an identified victim who are in imminent danger of abuse with lifelong damaging consequences. Now, that phrase, identified victim and imminent danger, are associated with duty to warn under Tarasoff. And so that's a separate case. It came up in California, actually, where a mental health professional, their client made threats against like an ex-girlfriend, and the therapist at the time was constrained by confidentiality. So what they did was they reported the threats to the police. They discharged their duty to the police, but and maintained confidentiality. But afterwards, the court ruled that they had an extended duty, a duty to warn the intended victim. And so all mental health professionals get training in Tarasoff when there is an identifiable victim and there's imminent danger. Then we break confidentiality and warn the victim. Here, it's a little slightly different because it's not a duty to warn, it's directly the duty to protect. We have an imminent harm to an identified victim, and no mental health professionals in the family courts are conducting a risk assessment for possible child abuse, which is an abomination. When the only cause of the child's symptoms is child abuse by one parent or another, and there is no risk assessment being conducted for the child abuse, that is phenomenal malpractice. Violations of standard 2.01, they're not competent. 2.04, they don't apply the knowledge. If you don't know the knowledge, you can't apply the knowledge. They're not even applying the DSM-5. Violation 9.01, basis for assessment. Violation of 3.04, avoiding harm. And they don't care. They don't care. They just disregard the AP Ethics Code. They disregard everything because in the family courts, the mental health people are allowed to do whatever they want. They can make up new roles for themselves, as quasi-judicial role of assisting the court in its decisions and not diagnosing pathology, an experimental role. They're allowed to make that up, an experiment on human subjects. They're allowed to make up this new assessment procedure and just out of whole cloth and just make up whatever they want, called a forensic custody evaluation, 6 to 9 months, $20,000 to $40,000, doesn't diagnose anything, doesn't solve anything. It's not meeting the needs of the parents. It's not meeting the needs of the children. It's not meeting the needs of the court. It's meeting the needs of the forensic custody evaluators to have a nice leisurely 6 to 9 month evaluation, get $20,000 to $40,000, and you don't really need to know anything or solve anything. And so this is just phenomenally bad over here. And so we need to get oversight, proper oversight. So forensic custody evaluations are an experiment on human subjects conducted in violation of all three principles of the Belmont Report, without a risk-benefit analysis and without the required protections for vulnerable populations. Forensic custody evaluators are routinely, universally, in violation of standards 2.01, 2.04, 9.01, 3.04 of the AP Ethics Code. Now, we should not be in violation of any standards, but here we have four. And they are all very serious standards. The two standards in that category are competence standards. So they're not even competent to be working with the pathology. 9.01 is about assessment, and that's what they're doing, the forensic custody evaluation assessment. And 3.04 is probably one of the most important of all the standards. It's about avoiding harm. So when you have that cascade of ethical violations, they don't know the knowledge, they can't apply the knowledge, so their assessments are not based on information and techniques to substantiate their findings, and it's causing harm to parents and children. That's a really significant issue, and has been going on for 40 years without oversight and with no ability to stop it. The New York Blue Ribbon Commission, the only overview or review that the practice has ever had, the New York Blue Ribbon Commission on forensic custody evaluations, found them to be, quote, dangerous and harmful to children, and they lead to potentially disastrous consequences for parents and children. So if we have a review by an institutional authority, New York Blue Ribbon Commission on forensic custody evaluations, that find them to be dangerous, harmful to children, and lead to potentially disastrous consequences for parents and children, why are they still being allowed? Where are the protections? Where's an IRB review for this experiment, institutional review board? What happened is, in all the rest of psychology, we work in clinical settings or academic settings. So we are required, and there's IRB review boards, and we're not allowed to experiment on people. But what the forensic custody evaluators did is they went into the legal system and convinced the judges to start ordering these custody evaluations, and there's no mechanism for review of experiments on human subjects in the family courts. And then the licensing boards and the APA just abandon these parents, and they say, we're not doing it, it's a court thing. And the court is accepting this incredibly low level of information, thinking it's quality professional information. No, they're just making stuff up. And that's another thing that bothers me, is not only is there rampant child abuse destroying the lives of children, for the rest of their lives are going to be destroyed because of the child abuse that's undiagnosed and untreated. Rampant spousal abuse, their whole life is devastated, these targeted parents, losing their children, traumatic grief. Not only that, but the courts are getting the lowest quality of information when they have these incredibly important decisions. The child's life is going to hang in the balance of the court's decision, and it's in the context of possible child abuse. And we're giving them just this awful, awful information that they can't use. It doesn't solve anything. We need to get the courts the highest caliber of information we possibly can. That's DSM-5 as a baseline, attachment, family systems, child abuse and complex trauma, personality disorder pathology. We need to be getting the courts good information, accurate information for which to make these decisions. That's on professional psychology. So while the courts aren't set up to handle pathology, they take too long, it's procedural stuff. They need to bounce it quickly out to the mental health system. As soon as we see this pathology, the court can refer it out to mental health. Mental health can do a path A, path B risk assessment, which parent's abusing the child, come back with a diagnosis, persecutory delusion or child abuse by the targeted parent, whatever the accurate diagnosis is. We can even get second opinions on them. We can get second opinions through telehealth, easy peasy. And so we can get all the second and third opinions Typically, what I recommend is you get somebody to do the assessment, and each party is allowed to appoint a second opinion consultant of their choice, and we put it all together and get all the doctors together and make a decision so that we get the courts excellent information, accurate information on which to base its decisions. The issue for the um, self-proclaimed parental alienation experts, the PAS experts, the issue with that is that they are facilitating the child abuse. And then they're doing it intentionally because they know it's what the DSM-5 diagnosis is, but they're withholding that knowledge from the public and from the courts, what the DSM diagnosis is, so that they can promote their fabricated pathology that they assert they're discovering. Parental alienation hides child psychological abuse diagnosis. It hides the shared persecutory delusion. It hides the factitious disorder imposed on another. It hides the spousal psychological abuse. It hides the ethical violations of 2.04, 2.01, 9.01, and 3.04 by the forensic custody evaluators. It hides the regulatory capture of the APA and state licensing boards by the forensic custody evaluator. That's Stigler regulatory capture. And it hides the institutional betrayal trauma of the now adult children and their parents, because everybody's fighting about this made up pathology and nobody is recognizing what it actually is. That's where my motion in Lamine, my respondent's motion in Lamine, is requesting from the court that we establish evidentiary standards. Because if parental alienation comes in, that's going to hide the fact that we're talking about child abuse. We're not talking about parental alienation. That doesn't exist. Nor are we talking about unicorns. We are talking about child abuse. And people need to start using that word. And we are talking about a delusional disorder. That's mental status exam of thought and perception. And we assessed for that. We're talking about a factitious disorder imposed on another, two major psychiatric disorders. We're not talking about made-up pathology labels. And I worked in child abuse. Okay, I worked up close and personal. I personally treated all four forms of child abuse: physical, sexual, neglect, psychological. And I've led the treatment teams that included CPS involvement. I know child abuse. I'm a child abuse trauma therapist. That's institutional betrayal trauma, spousal abuse trauma. This is trauma pathology that we got over here. And one of the things when we're working in the field of child abuse is we never use euphemisms for child abuse. We call it what it is. We don't say it's overly harsh discipline syndrome. No, it's child abuse. We don't say it's inappropriate affection. No, it's child sexual abuse. When it's abuse, say the word, because we need to get protections in. And so for 40 years, everybody's been deluded into this belief that it's not child abuse because we're using these euphemisms. More recently, even the forensic custody evaluators are bailing on this parental alienation stuff, and now they're creating their own made-up pathology labels. Resist, refuse dynamic, or parent-child contact problems. Use the DSM-5, please. If you want to propose a new form of pathology, do it after you use the DSM-5, not before, not instead of, after. Apply the DSM-5 as a basis for your scientific and professional judgments, and then we'll talk about your new form of pathology. Classic feature of abuse pathology: spousal abuse and child abuse and elder abuse. A characteristic feature of abuse pathology is to isolate its victims from reporting and rescue. Think about it. Spousal abuse, that spousal abuse husband, he isolates the spouse from her friends and from other people in connection. You isolate the victim. Think of sex abuse, that predator isolates the child from reporting and rescue. Elder abuse, you isolate the elder from reporting and rescue. That's a characteristic feature of abuse pathology. That's exactly what's happened in the family courts. They've been isolated, the parents and children, away from cl- clinical psychology, away from reporting and rescue. And all they're given is these forensic custody evaluators who don't diagnose and don't treat. And the clinical psychologists are staying away because it's too dangerous to work in the family courts. And they give it over to the forensic custody evaluators, thinking they're doing what they're supposed to be doing, and they're not. They're just financially exploiting these parents. And so there's no reporting. And then the licensing boards refuse to take these cases because they grant the forensic custody evaluators quasi judicial immunity. And it takes both parents to consent to the report coming in for review. And the pathological parent says, no, I'm not going to consent to the release of the report. So there's no licensing board review of any of these custody evaluations. I review them because I'm on the evidentiary side. So attorneys bring me these reports for review, and attorneys and their parents. So I get to see how bad they are, but nobody else gets to see that. They're isolated from reporting and rescue. And we need to break that. We need to break through that, which is entirely what this California Board of Psychology hearing is about. I'm putting my license on the line and my career on the line in order to break through the isolation for these parents and children, because that's the treatment for abuse, is to break that isolation. Get that little girl reporting to sex abuse. Get that spouse reporting to somebody about the spousal abuse so we can get rescue in there. So this is exactly what has occurred in the family courts with the parent and children who are being denied standard healthcare services of a DSM-5 diagnosis and treatment, while an unregulated experiment is being conducted on them regarding a quasi-judicial role for doctors, and while an experimental assessment procedure, forensic custody evaluations, is conducted on them without IRB review and in violation of all three principles of the Belmont Report. So these are the California legislators. There's four oversight committees, two in the Assembly, two in the Senate. The two judiciary committees have oversight of the courts. The two business committees have oversight of the licensing boards. So you have the Assembly Judiciary, Senate Judiciary, Assembly Business and Professions Committee, and the Senate Business Committee. Now, all states, all 50 states are in exactly the same position. This is across the United States. And so if you're in Florida or you're in Michigan or you're in Ohio or Pennsylvania or North Carolina, you can start doing the same thing with your state legislators. And my hearing is open to the public. And so you can sign in and get the Zoom link, and you can watch the 3 days of hearing. And your legislative aide from any one of these states. Now, I have testified before the Pennsylvania legislature, like in 2016, 2017, something like that. And so Pennsylvania was kind of moving there for a while. But things have quieted down because everything gets suppressed and it's institutional capture. So activate your legislatures to begin to look at this and to begin to look at their licensing boards as to why are they not protecting the citizens of the state from something the New York Blue Ribbon Commission has found to be dangerous and harmful to children and produce disastrous consequences and to lack scientific and legal value. Why are they allowing that? We need to get oversight onto the licensing boards and put a moratorium into forensic custody evaluations in the family courts. Bring clinical services back in of diagnosis and treatment, diagnosis of child abuse and spousal abuse and treatment, and fix things, get things solved so these kids don't have destroyed lives and parents don't have destroyed lives. And we now have 40 years of institutional betrayal trauma. And that requires the treatment for that. Freud, F-R-E-Y-D, requires that the institutions acknowledge what happens. So you think about the Catholic Church and sex abuse scandal. That's institutional betrayal trauma when they're moving the pedophile priests from parish to parish and not addressing the problem. First step is for the institution to acknowledge there's a problem. And so in the family courts, what we need to be able to do is we need to go out to these now adult children and their parents who had their lives destroyed and get treatment for them. This is trauma. And so we need to go back out, but the institutions need to say it's our fault. What Again, I've worked child abuse. The very first thing we say to a child abuse victim is we say, it's not your fault. You did nothing wrong. Bad people did bad things to you. We're going to protect you. That's the phrase we say to the children. It's not your fault. You did nothing wrong. And that's what we need to be able to say to the institutional betrayal trauma, to the children, now adult children, and to their parents. It's not your fault. It wasn't your fault of what happened. It's not even kind of the fault of the pathological parent. They're got unresolved trauma. They're pathological. They need treatment. It's not their fault that they're damaged. It's the fault of the people who should protect, the psychologists and the court. Now the court gets off a little bit because it falls to the psychologists. We're the bad ones. Okay, we failed to protect. We got off doing this experiment. We got on the wrong track in the 1980s, and we never course corrected. But it's time to course correct. It's time to end the pathology for the children and families in the family courts. And once we end it anywhere in America, if the California Board of Psychology puts a moratorium on licensing board forensic custody evaluations, that's going to ripple across all 50 states. It's going to ripple up to Canada, which will ripple down to Australia, which will ripple over to England and Europe. And all of a sudden, we solve this for everybody. What I would ultimately recommend is that we get a pilot program for the family courts. In California, I'd recommend we put the principal investigator at the Stanford Forensic Psychiatry Department, and we come up with a pilot program to develop the diagnostic and assessment and treatment protocols. But in California, we also want another location down in Southern California, because it's kind of a two-part state. And what I recommend is you put the diagnostic assessment protocol, you give that to the Stanford Forensic Psychiatry, because it's psychiatry. We got two major psychiatric disorders. And so we give them that primary development. And then in Southern California, we have a group of universities headed by UCLA on the diagnostic side, Pepperdine and Alliance University on the treatment side, and task them to come up with a treatment protocol. Now, both would be working on both, so they'd be sharing about assessment diagnosis, but it would be the focus of each one of those site locations to come up with a diagnostic assessment protocol and treatment protocol. Then you get the two law schools to work out what the legal orders would be on that, and so that parents can do this pro se. They don't have to hire an attorney necessarily. Well, if it goes into the court and we got this high conflict custody litigation, oh my God, that's financial abuse. These parents are spending hundreds of thousands of dollars on legal fees. That just goes right out the window. That should be going to the kids' college education. There's no need for that. If all the professionals, the attorneys and mental health professionals know what's happening, and the judges, the moment it hits the court, everybody knows, and you get the proper orders going through. And so with AI, the parents would be able to manage that, and we can bounce it out to get a proper diagnostic assessment and get the court the proper information and make the proper decisions. There's no reason for this to be such a big problem. It just needs clinical psychology in there instead of these forensic custody evaluators. So with that, that's my daily update for today. And so I'll check in tomorrow with my Sunday morning coffee and sort of give you an update of where everything stands. So take care, everybody. Good luck.